Thank you, Honorable Chairperson, ma'am. There are very important points which have been raised by Honorable members, and I would like to respond to them in very brief. Very erudite explanation and kind of discussion about this judgment. I thank all the Honorable members who participated, and I have special thanks for Dr. Patnaik and Mr. Reddy. Both of you are big lawyers, very important lawyers, and you have noted some points which are very important, which probably I didn't want to say. As Mr. Reddy said, Honorable Mr. Reddy said, this is a law in which the language has been very simple, so this is definitely not a lawyer's paradise. So thank you very much for noting this point. Dr. Patnaik mentioned that data minimization principle has not been included. It has been included. If you read the clause 6.1, the data minimization principle is included. Second, regarding the voluntary undertaking of section 32.4, or let me say clause 32.4, the clause 32.4 is applicable when the Data Protection Board has heard both sides. So that's why it is written may, it's not written shall. So that will cover basically this provision. Third, the question about applicability was raised both by Mr. Reddy and by Dr. Patnaik. Mr. Reddy mentioned it in the context of cross-border data transfer. The world of data, Honorable Chairperson ma'am, doesn't follow the boundaries of physical boundaries of nations. So that's why the entire world today, when we legislate anything related to data, the concepts which are evolving today, some of these concepts have been introduced in the bill, have been included in the bill, and there are many more things which are still evolving. This is a field where so many things are happening. Practically every quarter something new happens. New AI has come. So we wanted the entire bill to be drafted in a way which is technology agnostic, which should be able to stand the progress of technology without requiring amendment again and again as and when new technology comes. That's why some of these provisions have been kept, and many of the things will evolve as the Data Protection Board gives its rulings and people understand what's happening, people understand what needs to be further done. So that flexibility is there, and we have kept this bill primarily on principles. We have not kept it prescriptive, so that gives the flexibility of evolving as the sector evolves. There are many points about startups. The carve-out is only on the compliance. Carve-out is not on violation of the basic principles. It is carve-out on the compliance, and when a startup proves a product, then it becomes a regular. So if you read the section 17, the carve-out, it doesn't mention startup. It basically mentions certain classes of data fiduciaries, so which gives us the flexibility to create a regulatory sandbox, and once the regulatory sandbox is used for proving the product, then the entire law can apply. Other things about clause 37, that is about repetitive violations. If any data fiduciary doesn't respect the law, then obviously some stricter force has to be included in the law. Mr. Vijay Sai Reddy mentioned about surveillance. This entire bill, the concept of data protection has been created, the legislation has been brought in primarily for the purpose of bringing in protection of personal data, and as far as any surveillance and other things which are concerned, they are always considered as per law and as per the very well established procedures framed by the Honorable Supreme Court of India. Another honorable member mentioned about research of medical data. The research part is excluded from the, exempted from the bill, basically by the section 17. You can kindly read that section, it will give you the details. And protecting medical health data is also personal data, so that will also be protected. I thank honorable members for excellent discussion. In the end, I would like to mention one more very important point, ma'am. Our country is a very diverse country. We have a very rich culture, a large number of languages are spoken. In this bill, we have attempted that all the languages mentioned in the 8th schedule of the Constitution should be given due importance, and that's why any consent form, any notice will have to be offered in any of the 22 scheduled language, 22 languages of the 8th schedule. So this will give a lot of accessibility to the common citizens. Thank you very much.